The information provided on this show does not, and is not intended to, constitute legal advice. Instead, all information on this show is for general informational purposes only. The information provided is not a substitute for legal advice, and we recommend viewers consult an attorney for specific legal matters.
And welcome to our Condo Craze and HOAs channel. I'm Karen Curtis with attorney Eric Glazer, and we have a new spooky set.
That looked great.
It does. I
Yeah.
love it.
Kudos to you, Robert.
Yeah, way to go,
worked, like,
Robert.
all freaking weekend putting this together.
Oh my gosh.
Yeah. So, Robert, thank you so much.
And which
Appreciate it.
Is
Sure.
one of us supposed to be a witch here?
Well, you're the female. I mean, can't be a male witch, can you?
Sure, you'll be a warlock.
A warlock. Okay, I just learned something.
No, you never watched Bewitched when you were a kid?
But that's a she.
There was a warlock too.
Oh, I didn't know that.
Oh my
okay,
God.
Never mind.
All right. So anyway, welcome back, and we're here every Sunday at 11 a.m. and except when we're not. And we are made possible by our fantastic sponsors who truly offer you the best services in South Florida, including our diamond sponsor, Best Roofing. We love them. And Eric is board certified by the Florida Bar in Community Association Law, Condominium, and Plan Development Law. He has an office here in Hollywood that's Glazer and Sachs, and offices in Orlando as well. And that's it, right? Nowhere else?
Correct.
And so we're going to answer all your questions and all your chat questions and phone calls about what makes life in your condominium or HOA absolutely crazy from 1 minute to the next. The number to call, 717-GLAZER-8. That's 717-452-9378.
Yes, and don't forget to subscribe to two things. Number one, like we say each week, the Condo Craze and HOAs channel on YouTube. You don't have to watch the show live. You can watch it at your convenience. And subscribe to our email list. You can do that at condocrazeandhoas.com. By subscribing, you get announcements about the show, announcements about our seminars, announcements about all the new laws, and a whole lot more.
And don't forget, you can also follow us on Facebook, Apple, Spotify, Instagram, LinkedIn. And you guys are doing a great job of subscribing to the show.
Absolutely.
Very
a lot.
nice.
We have 3,500 subscribers for this show right now.
Yay.
And we do a blog every single Monday at condocrazeandhoas.com. And before we get going, I just want to thank everybody who showed up at our Condo Craze board certification class in West Palm Beach this week at the L&L event. It was really so great meeting everybody and answering everybody's questions like always. And I look forward to seeing everybody this Tuesday in Tampa. We start the drive tomorrow at the L&L HOA Expo and Condo HOA Expo in Tampa on Tuesday, 8 o'clock a.m.
You're going to start driving tomorrow?
Yes, because it starts 8 o'clock in the morning on
Oh.
Tuesday. So I'm not leaving my house at 3 o'clock in the morning, so we sleep over tomorrow night.
Okay.
Yeah.
Gosh, you're
It's
the
fun.
best.
It's fun.
And last week you said that while you were teaching in Broward, everyone was looking at you like dazed and confused because there is just so much to know. They were like, their heads were hurting.
Yeah.
Are you also giving out analgesics during this thing? It's like
They want it.
what
I
they
know
do
that.
in Palm Beach, were they equally as
So let me tell you, I
confused?
think Palm Beach was even worse.
Oh dear.
Yeah, I really mean it. People were actually raising their hands
Oh.
and they were complaining about all the new laws and how they're so confusing. And there was really like, all kidding aside, there was like a minor revolt in the classroom. People were like losing it.
Really?
And and everybody admitted, even if your condo had only 50 units in it, there's no way that a board by itself can do this without professional management anymore in order to comply with all the new laws, all
Right.
the new requirements. It's like impossible. But we're going to arrange a show that's going to discuss all of that. And like we said last week, we're ready to have some board members on the show who volunteer for their community. And we want to know what you guys think. Are you still hanging in there? Or has it gotten to a point where, wow, it's just too damn hard? And in order to get everybody on the show that wants to be, you got to go through Robert. Robert's the gatekeeper. So, Robert, how did they get in touch with you?
They should contact the phone number that's on the screen right now, Robert at condocrazeandhoas.com.
All right, go through Robert. We'd love to have you guys on the show to talk about, again, Do you want to hang on? Do you want to stay in and continue to represent your association? Or has it gotten to be enough?
Are
We'd
we
love
having them
to
in the
hear.
studio,
Yeah,
or
we want them here. Absolutely.
you have to wear a costume
Right. Yeah, we'll talk. Well, we're gonna have a lot of fun next week's
next
show,
week?
but
Yeah.
yeah, we're gonna talk about which of the Halloween characters your board reminds you of most. Now, people are thinking bad, is it a witch and things like that, but it could also be about Superman or Superwoman, something like
Right.
that.
I see
So
something
it's not
positive.
necessarily all bad.
And also trick or treating and 55 and overs. What do you hand out?
Oh God, that's gonna be hysterical.
Depends.
All right,
Okay.
let's move on. Let's talk about closed door meetings. I know that's why a lot of you tuned in for today.
Okay, so we know that at any time a quorum of the board gets together and talks about the association, even in the pool, that's a meeting.
Yeah.
And it has to be properly noticed, and the owners have a right to attend.
Absolutely, Karen. Agree with that completely. And that's because, like you say, it's a meeting. It's not a workshop. I don't know how that phrase, came into existence. It's not a gathering. It's not an off-the-record meeting. It's a get-together or any other fancy term you want to use. Bottom line is it has to meet the notice requirements under 718 or 720. But there are times that the board can get together and meet privately. All right, very few exceptions, but let's discuss that. All right, number one, what boards want to know is how can they do this? How can they get together and meet privately and keep the community out, at certain times? So Florida Statutes 718 and 720 mirror each other in this regard for condos and
Imagine
HOAs.
that.
Yes, they do. And there's two ways that you can have a closed door meeting. All right, number one, meetings between the board or a committee and the association's attorney with respect to proposed or pending litigation.
Okay.
If the meeting is held for the purpose of seeking or rendering legal advice. Okay. Number two, board meetings held for the purpose of discussing personnel matters. Right. The first exception, pretty simple enough. If you're discussing proposed or pending litigation, as long as the attorney is present, the board has the right to make it a closed door meeting. Pretty simple, right?
Yeah. So, suppose the attorney is not actually present, but there, either by Zoom or by a phone call.
Okay, it's a good question because that's how everybody's appearing, including oftentimes your attorney. And that's fine, right? That's still good enough to make it a closed door meeting if your attorney is there, either by Zoom or by a phone call. The attorney does not need to be physically present at the meeting, as long as that attorney is there one way or another.
So, if it's going to be closed door and an attorney-client meeting, doesn't it still need to be properly
Yeah.
noticed?
Yeah,
You
it
need to
does.
know
Yeah,
about it.
yes, the unit owners have a right to attend. Not a right to attend. The unit
know.
owners have a right to know that the meeting is going on. So yes, it does have to be properly noticed.
Now, they can all be sitting together, but it's not a meeting if they're emailing each other.
That's correct. That's yeah. How bizarre that. And every time I tell that
Yeah.
to the community, everybody kind of like breaks up and can't believe it.
Yeah.
But it is what it is. What it is. Now the second exception is a little tricky, right? Board can have a closed door meeting if it's regarding a personnel matter, but what
What does
is a
that mean?
personnel matter, right? Who are personnel exactly? And there's actually an arbitration case that clears this up at least a little bit, and it's the name of the case is called Vega versus the Clarendon Condominium Association. And for those of you who like to look it up, it's Florida arbitration case number 23-06-1977. And again, the name of the case is Vega versus the Clarendon Condo Association. So here's the facts in the case. The board held 7 closed-door meetings alleging that they were meeting regarding personnel matters, and they were discussions pertaining to the then current management company, the front desk security company, and proposals from companies intending to replace the management company. And the arbitrator held that in that case, these meetings were not about personnel matters at all. Why? Because that association was not paying salaries to those companies, right? They were not getting W-2 forms for tax purposes. The companies were third-party independent contractors who actually served as agents for the association. They weren't employees. That's the bottom line.
Huh. Okay.
Yeah.
So the Florida Administrative Code actually discusses this. It's Rule 61B-23.0022. It says, quote, a worker shall be considered an employee of an association where the association pays or deducts for or on behalf of the worker Social Security tax, unemployment compensation taxes, and federal withholding taxes.
Exactly. Okay. And the management companies here, the association is not withholding taxes or Social Security, so they're not personnel, right? Even under the rule. And the same thing applies to your landscaping company, your accounting firm, your valet company, and any other company that the association does business with, right?
But
They're
you might
not
have a contract
employees.
with them.
You might have a contract. Well, you do have a contract, but that does not make them an employee.
So
Typi-
you had someone last week call in about possibly giving them a 401k
That's if they're going to work specifically, and that's a good
for
question.
you.
That's if they're going to be a specific employee. There's going to be a contract between the association and that specific employee, and that happens all the time too.
Okay.
And that person can be an employee of the association.
And that would be personnel.
That would be personnel, exactly,
Okay.
Karen. Right, hit the nail on the head. But the bottom line is, it's confusing. When in doubt, ask the association's counsel here. Okay, some situations you may have to do withholding, and you're not doing it. So, but to state the obvious, if the association does not use a company, for example, like you say, for management, and employs an in-house manager,
Okay.
right, then yes, that's a personnel matter.
That is a personnel.
Absolutely, right. But if you're using a company and you're not withholding taxes, they're not personnel, right? They're an independent contractor, and you cannot have a closed door meeting regarding those companies.
And you can't have a closed door meeting regarding personal matters.
No, you can't. That's got to be open. Your personal matters need to be open, right? Play on words. But hey, I after the show, I got to get out of here quickly. I just want to announce this on the air. And before we go to a break, I'm going to a birthday party right after the show. And who is it for? Someone who I know you love and
I
hold dear,
love
right? I know.
your mom.
And a lot of viewers to the show actually got to know
Bernice.
her after their Bernice. And I'm so blessed to have these birthdays for her. She is turning 94 years old tomorrow.
That's
So,
not old.
Mom, just want to say I love you. Happy birthday. And yes, may you still have many, many more. Okay. All right. But let's hear what our listeners have to say. Is your board having too many closed door meetings that should be open to everybody else? Or drop us a question or comment about anything else you want to ask in the condo or HOA world. The number to call 717-452-9378, 717-Glazer 8, or drop us a question or comment in the chat box on YouTube. We will be back right after this.
In South Florida, the transition from bright sunshine to heavy rain and hurricanes can take a toll on your property's exterior and structural integrity. Cracked stucco, spalled concrete, they're more than eyesores. They can signal deeper issues. Now, with new Florida laws involving structural integrity requirements, we want to help you meet your milestone inspections and maintain the durability and beauty of your building. Since 2004, PD has been the trusted expert in structural concrete restoration, painting, and waterproofing for condominiums and commercial properties. Visit pd-concrete.com or call us today.
We are DMI Paving and Seal Coating, Florida's parking lot experts. We specialize in asphalt paving and repair, including pothole repair, seal coating using JC7 or polytar, concrete curbs, ramps, and walkways, and striping and pavement marking, as well as ADA compliance. We service commercial properties, including homeowners associations, apartment communities, shopping malls, warehouses, stadiums and arenas, and more. Experience is worth more than anything in an industry like ours, and our staff has decades of it. We have specialized equipment for any job, regardless of size, saving you time and money. DMI has a reputable history. We have been in business since 1956. We serve the state of Florida from 6 locations. Let us bid on your next parking lot project. Visit us online at dmipavingandsealcoating.com.
And welcome back to Condo Craze and HOAs, our YouTube channel. And this hour, half hour, is brought to you by our wonderful sponsors, HCMC and Affinity.
Yes.
Mr. Sexy still at Affinity?
Yes,
Mr.
he
Sexy Voice
is. He's still there. Raphael, we want you back on the show. Let's go.
We love you. I got this email from our property management company, Campbell,
Where you live.
where I live. Please don't reply. So it's regarding, good afternoon. A resident's lost their walker and possibly a pair of black slippers or shoes They may have been walking somewhere between building 23 and 25. I'm in building 25. The walker may be missing a wheel. If it is found, please contact the manager.
That's scary because
Right.
somehow that person is walking without their walker and lost it. How did they lose it?
I know.
It's bizarre email.
I thought
you
that
know?
was strange.
Right. The only thing I can tell you is thank God the person's
The
not
person-
lost, and you know, at least it's only the walker.
Yeah.
Right. But it's it's a very strange
Might be
email
missing a meal
from the
or wheel.
management company. Why would someone steal the walker?
Without a
Unless they
wheel,
needed
too.
it for themselves, right? Isn't
Right.
that crazy? That
And
would
their
be
sh-
awful.
And their shoes.
And their and their shoes. Kind of a place that you live in. It's like Rikers over there. Okay. 55 and over Rikers. Okay, how about we take our first call of the day? How about we got someone's calling from Boone Beach. I don't even know where that is.
Boone Beach. Let's go. Let's see.
Number 5, it says.
Good morning.
Hey, good morning. Where's Boone Beach?
Boynton Beach.
Oh,
Must look like
Boynton
Mumble.
Beach. There you go. All right.
AI translation.
Yeah.
Thank you, AI.
Thank you so much. Thank you so much.
Boone
And
Beach.
also, congratulations on
Boondocks.
your son getting into law school. That
Thank
was
you very
nice
much.
seeing
Yeah,
last week.
it's been a good couple of
Okay, my
celebrations
question
this
is-
week. Yes.
I see in the future the name change to be Glazer, and Sachs.
Yeah, I told you
see
though.
that in the future.
Yeah, he wants to be the first Glazer though. Not cool.
Really?
Already told me. Yeah.
The HOA board approved a contract for a consulting firm. Consulting firm gathered created the information, sent out the RFPs, received the proposals, evaluated them, and submitted a report. Community received the report, and now I'm asking as a director for a copy of that report, and they're saying it's not ready for release. I believe the report is ready for release. It's addressed to the community, not to an individual. And they also sent back a letter of communication about what they feel is wrong with the report. And I believe I'm entitled to see that.
Of course
Am
you
I
are.
right or wrong?
100%. You're entitled to see all of that. You know, anything here's the rule when it comes to official records. It's basically anything related to the operation of the association. Clearly, those documents which discuss the condition of the property of the association is clearly a document that's related to the operation of the association. And I will tell you that over the years that arbitrators have defined that term very, very broadly. If there's any way you can make the argument that a document is related to the operation of an association, you get to see it. So, you know, you can tell them that you've heard it here. They better turn that record over, because if they don't, you know, it's something that you can go
Specific
forward with.
paragraph in 720.
I'm sorry. Yeah, it's in both 720 and 17. Anything related to the
What is
operation
the
of the
specific?
association.
What is the specific paragraph?
I think it's
720?
it might be 305. I don't have it in front of me. 72305, I believe it is. Okay.
Thank you.
Even 723 or
Enjoy your
305.
mother's birthday.
Thank you so much. Okay. Who else we got, Ron?
Let's go to Joe.
All right, Joe.
Hey, good morning, guys. Hope you're doing well this morning, and happy birthday to your mom. It's nice that you still have her with you, Eric. And,
Absolutely.
just enjoy her, because mine's been gone for a while.
Uh,
Eric, what can we do about an owner who's always harassing the board, management, the vendors? She's already received a letter from our previous attorney about a year ago. Nothing
Okay.
has changed. Previous managers, management companies, and even vendors have left the building all because of her.
Okay, so that's interesting. What you need to do is start rounding up affidavits from all these people who were, you know, attacked, harassed, whatever you want to call it, especially from vendors. Vendors would be the best one, especially ones who are going to sign an affidavit that say they walked off a job. And you want to file, give the person notice that you're going to file an action against them first, an arbitration action, calling them a nuisance if they don't stop their behavior. And if they go forward, there's actually even an arbitration case out there, pretty interesting, where, you know, you ask for an injunction to make this person stop. There's actually an arbitration case that says where you get enough affidavits, the arbitrator even entered an order in that case of an injunction requiring that person to stop their nonsense, even before the respondent, the owner, had a chance to respond to the initial complaint. Because
Oh.
the arbitrator said, wait a minute, they submitted like 10, 20 affidavits here, in order for me not to grant this injunction, I'd have to find that all of these people are lying.
Right.
So without even giving the other side the right to file in a response to the complaint, the arbitrator entered an order of an injunction requiring that person to be a good boy or girl. I don't remember who the defense.
So the more affidavits you get, the better.
More affidavits you get, the better. But line them up. Start getting them early. I think that's a good practice in a lot of cases.
What happens if she doesn't stop?
Well, then you proceed with the arbitration. The arbitrator enters that order, and that order is enforceable in a court of law. So then you could bring the matter to court to enforce the arbitration judgment, and then, as you know, a judge has wide range of remedies, including incarceration.
Yeah, if they ignore an injunction.
If the person violates the injunction by the arbitrator, the circuit court can enforce it, and the circuit court judge can do whatever they want to do, right? Including, like I said, incarceration. So that's where you want to go, Joe.
Okay, super. Thanks, Eric.
Okay, thank you. Keep them coming, Rob.
Bye-bye.
Let's take one more before we go to the break. Violates the injunction by the arbitrator. Yeah.
All right, let's go to the next caller. Looks like Celine, but please let us know.
Yes. Yes. Hi, Karen, and hi, Eric.
Good morning.
Bonjour.
Good morning. I call you because I live in a condominium in Miami, and we get a letter from the association that our annual board meeting is scheduled on December 15th.
Okay.
I live in this condominium for 26 years, and in the declaration it said that it has to be the first secular day of December, and for example, last year it was in December 2nd. So, and the thing, December 15th, it's also the first day of Hanukkah, and we have a lot of Jewish people, religious, in this condominium. And I feel like it's not really respectful, not only not to respect the, the declaration of condominium, but also to do it on a day that it's important for some unit owner. So is it legal or what can I do?
All right. So there's a case out there that says the association must hold the annual meeting on the date as provided for in the bylaws. Okay. So yes, they are holding that meeting illegally on an illegal date. Now, the problem is, as you know, you got to give 60 days notice, advance notice of the meeting.
Yeah.
So my guess is they started the process late and they're like, we can't do it in the first week of December. Now we got to do it in the second week of December, starting the third week, actually. What the problem is, they picked a bad date. If you're telling me there's a lot of Jewish people in the community that are going to not be able to make it, right, and want to go, and it's the first night of Hanukkah, here's what I would tell them. Here, you want to know what I tell them? Reschedule the damn meeting. Do the goddamn right thing, okay? Do the right thing. Reschedule the meeting, okay? That's the only thing I could say. Let's take our bottom break, the first break of the hour. Keep the calls coming in. No, the bottom break of the hour.
Yeah.
717-452-9378. 717-452-9378. Be back right after this.
there are very large management companies and there are very small management companies. And I think Affinity sits somewhere in the middle of that, where they are big enough to provide you with all of the back of the house services, the accounting, the infrastructure, the support systems, but small enough to be high touch.
We believe at Affinity that we do the 9 to 5 so that you don't have to do that.
And welcome back to the second half hour of Condo Craze and HOAs here on our YouTube channel. So happy that you are here. If you like our new set, let us know what you think. We've all, Robert kind of went nuts with the Halloween
Go nuts. I
thing.
love it. I
yeah.
absolutely love it.
Yeah,
Looks
it's
great.
fantastic. But again, the number to call if you have a question for Eric, he's board certified in Community Association Law, 717 Glazer 8 with a Z. That's 717-452-9378.
Hey,
And you've been busy with your classes.
yeah, it's
teaching,
great.
teaching.
Let's just tell everybody really quick, education is now mandatory. So glad I got that passed. Worked my whole career to try to get that passed.
Your legacy.
Yep. And so I'm going to be teaching the Condo Craze board certification class that gives you the initial 4-hour class for condominium members, no condominium members. We teach the requirements for new HOA members, and we teach the 1 hour of continuing education for condominium board members.
Wow. So you just did Palm Beach and you did Broward. Now
Yep.
you're in Tampa. You're going to leave
Yep.
tomorrow so you can be there for the 21st.
Yep, we'll see
Starts
you
at
Tuesday.
8 a.m.
Not too late to register for those that are listening
Okay.
in Tampa. Okay, just for all of them, go to condocrazeandhoas.com. But after Tampa on the 21st, we'll be in Bradenton on the 29th, a week later.
So you're not going to stay there. You're going to come
Right,
home and
gotta
go
come
back.
back,
Okay, Miami. You're going back to Miami.
We're going back to
November
Miami.
5th.
And then Orlando concludes the season on November 12th. And Karen, like you said, we teach so many different topics. We won't name them all, but I'll tell you what the topic that is the most important right now, by far.
What's exploding everyone's heads?
No, as amended from time to time language.
Kaufman
I'm sorry.
language.
All the
Because
Kaufman
it
language.
dictates what's going on.
Yeah, because they're smart. People are getting so
Yes.
smart when it comes to this, and they're like, wait a minute,
Yep.
this new law changes everything.
But maybe
we don't
not.
have as amended from time to time language. Eric, do we have to listen to any of this? And the answer may be, no, you don't.
That's huge.
So, yeah, it is huge.
I'm
and
so
it's
proud of
creating
everyone.
so much confusion out there about whether or not they even need to listen to this, or, well, at all, or
Do-
not.
Do they know where to look for the
They
Kaufman
do. They're
language?
telling you, we've been teaching it for so long.
Okay.
People are smart.
Okay.
I'm really, like you said, I'm really proud of the people that show up.
Yeah.
They do, and I don't mean that in a demeaning way. I'm telling you, the intelligence of the people that are showing up already, everything they know is incredible. They're actually spending, people, mind you, these classes, if they want to, they can take them online if they want to. They can turn on their computer and come back in 4 hours and get the credit.
No, but they
the
would
people
rather
that give
learn.
a damn, they'd rather learn. They're
And
smart.
this Kaufman language, so all these laws that passed about having to go to your SIRS and all these reserves and everything, if you have the Kaufman language but if you don't have
if you
it,
don't,
then the law doesn't apply to you.
maybe there's maybe if you don't have the as amended from time to time language and your documents allow you to waive reserves, certainly a good argument to me that you
I
have the
see.
right to waive reserves.
Yeah.
Right? The contract is being changed.
That's
in a
right.
significant way.
And you went to the Supreme Court and
Yep.
they said, no, we're not going to go with this because it's
There's-
a contract.
Correct. It's a contract. And the bottom line is if the contract's being changed, can't do it unless you have the as amended from time to time language. The contract allows you to waive reserves. The statute says now you can't. Well, who wins, right?
Your condo docs are more powerful than the Florida state law.
Right, exactly. That's what the
Could
Florida
be.
Supreme Court ruled.
That's what they
right?
did.
So again, sign up. Let's continue to talk about all this stuff and a lot more.
Yeah.
Just go to condocrazeandhoas.com.
It's free. He feeds you.
Yep.
You get a certificate.
No reason not to come.
Yeah.
Don't lower yourself and turn your computer on for 4 hours and come back. That's not the way to learn this stuff.
No.
Have more confidence, faith, and dignity, quite frankly, than to do that. All right, how about we go to the board? Joseph, in a multi-condominium association, is the elevator a building elevator, a general common element, or a limited common element? Okay, so let's go through that.
That's a good point.
What's a multi-condominium? A multi-condominium is, let's say, where you have 5 different buildings, each one governed by a different declaration of condominium, right? But one association being in charge of the whole thing. but there's 5 different condominiums.
And that
okay?
association can be an HOA.
No.
Yeah, I have. That's what we have.
Oh, the master you're talking
Yeah.
about. Yes, I'm sorry. I
Yeah.
apologize. Yes,
Yeah.
that doesn't necessarily have to be a 718.
Right.
Very good. Don't correct me. I'm joking. So yes, that HOA, that master can be a 720.
It gets
You're-
really confusing.
You're 100 right. It gets really confusing. Right. It's really, really complicated stuff. Okay. The question is that you had a question about the elevator that's in each building. That elevator is a common element of that building, of that condominium. Okay. It's not a limited common element, because a limited common element is a common element that's specific to a certain unit. Only that unit could use it, such as the balcony for that unit. So it's not a limited common element. It's a common element for that specific condominium, and it has nothing to do with the other condominiums.
And
Okay?
even though the people on the ground floor don't use it, you still have to pay for it.
They got to pay for it. They got to chip in for it. Exactly. Next question from George. Is a board meeting to discuss a contract with a potential or existing vendor a personnel matter? And no, what we learned, it's not.
Contract.
Why? They're a independent contractor that you may be doing business with. They're not even that at that point.
Right.
Before you're meeting with them, they're
right.
nothing, right? They're just a potential vendor that you're going to be doing business with. So the answer is no, that's not personnel matters, because you're not withholding any taxes, Social Security, right, from that
Right.
entity. So the answer is no, it's not a personnel matter. No, it can't be a closed door meeting, which is why what a lot of boards do, let's say you have a 5-member board,
Yeah.
they'll have a 2-member committee,
Oh.
right? There's no quorum. So they'll send that
Oh,
2-member
okay.
committee out to meet with that vendor, and that committee will report to the 5-member board.
What happens if the board is meeting with a quorum behind people's backs and you don't know about it?
What can you do?
What can you do?
So the question is, if you go to the DBPR, and if you're a condo, there's somewhere to complain to, right? If you're an HOA, where do you go?
SOL.
Yeah, correct.
Okay.
Okay. All right, back to the phones, Rob.
All right, let's see the next caller. I don't see your name, but if you hear a beep, please let us know your name.
Hey, who do we got? Good morning. Hey, good morning. All right.
You are live. Looks
5,
like
4,
Edwin.
3, 2, 1. Is it Edwin? Hello.
I hear you breathing.
All right, next. All right, Rob, we go to the next call rather than keep this going.
Okay.
All right, next call.
Go to, looks like Lee.
Lee.
I wonder if the person got stage fright, right? That happens. trust me.
Hi, Lee. Hi there. My name is Lee.
Hey, Lee, good morning.
Hi, Lee.
Good morning. I'm calling from St. Pete Beach. 2 quick questions for you. First one, for the closed door meetings. What are the minutes requirements for those? I believe they still need to
That's a good one.
provide some sort of minutes. It doesn't have to exactly say what they spoke about, but the fact that there should be a record that
Yeah,
the meeting was held,
I think there
starting
should
time,
be.
ending time, and who attended.
Yeah, that's true, but you got to be careful what you do with those minutes, because you have to make sure that unit owners don't get a chance to see those minutes, right? Because what's the purpose of having a closed door meeting? You want to make sure the community doesn't know what's going on. For example, the litigation strategy of your lawyer. If you're going to write minutes and someone in the community asks for copies of those minutes and you wind up turning them over, right? Kind of defeats the purpose of having a closed door meeting. So yeah, there can be minutes, but those minutes better wind up in a book that says closed door meeting
It's
minutes, and that
confidential.
confidential, and nobody can see them.
Right.
Okay?
Aren't there supposed to be some sort of a record of a minutes for the owners that says a legal meeting was held, discussion held with attorney, who the attendees were, and what time the meeting started and what time the meeting ended.
Not
just
that I know.
record.
I don't believe there's anything in the administrative code or statute which actually states that. And I would say that one thing that probably does need some corrections, some additions, is definitely the Florida Administrative Code rules regarding minutes, because there's very, very limited guidance at all. And most of the time when we talk about this, there's really no firm set of rules, and I think there should be. But I don't think if it's a closed door meeting that the unit owner should be able to see minutes of any kind. It's certainly not required as far as I'm concerned. I hope that answers your question.
Second question.
Yeah.
Second question for you. There's a every Thursday meeting that the board has with an on-site vendor that is our construction company that was hired to do all the hurricane remediation to all the flooded out first floor units.
Right.
That meeting is being held every Thursday, and there are, I mean, it's business discussion, and they are doing that without any notice. Owners are not allowed to be there, and they're not providing any
Okay.
kind of feedback or minutes.
So
What
did-
about something like that?
So what did we learn today, right? We learned that meetings with someone who's a vendor to the community, right, like a contractor, but the board is not withholding Social Security taxes, right? Is not withholding any federal taxes, right? Then that person is not an employee. It's not considered personnel matters. So if a quorum of the board is meeting with that company, that meeting is a meeting that needed to be properly noticed, and the unit owners have a right to attend. It's not a meeting that can be closed door as a personnel matter. Okay?
Even though the condo attorney, the association attorney has said they don't need to. This is being the attorney is attending every single time.
Well, if the attorney is there discussing potential litigation, that's something else. But if the attorney is there just to hear what the contractor has to say, then I'm sorry, it's not a closed door meeting. Again, why? You're not withholding taxes. And number two, even though the attorney's there, it's not regarding potential or ongoing litigation. So it is an open meeting. End of story. The unit owners have a right to be there. Okay? You got it. Let's do this. Let's take our final break of the hour. Don't wait for the last second. 717-452-9378. Again, 717-452-9378. We still got time also to drop us a question or comment in the chat box on YouTube. Back right after this.
For mitigation after a catastrophic event, building restoration, repair and remediation consulting, or Senate Bill 4D inspections, please visit rimkiss.com.
All over the world, people have plumbing problems. These problems can be expensive and destructive to fix. Have you ever wondered if there was a way to take care of your plumbing problems without destruction and an outrageous price tag? Welcome to Pipelining Technologies, Inc., where we specialize in fixing your problems without demolition and minimum cutting by means of pipelining. Pipelining is the ability to take a pipe damaged by root intrusion or long-term deterioration and make it new. By means of inserting an epoxy-saturated liner into the pipe and allowing it to harden or cure, leaving behind a brand new pipe.
That sounds great. How can I get pipelining in my home, commercial building, or condominium?
Simply fill out our online contact form and a pipelining representative will get in touch with you in a timely fashion, or call us directly at 561-853-5463.
Welcome back to the final segment of Condo Craze and HOAs here on our YouTube channel. So happy to have you here. And we are talking about whether or not your board can meet privately if they have a quorum.
Yeah.
And we're taking your calls if you have any questions for Eric. He's board certified in community association law, that's condo, HOA, etc. 717-452-9378.
And it's apparent that a lot of people are obviously complaining that their boards are having these closed door meetings. Maybe not getting the best advice as to when you can have a closed door meeting. And well, at least today you have something to tell your board to listen to, and you actually have an arbitration case that you can tell them to read.
And just because the attorney's there, don't let them, scare
It
you.
means nothing. If
it means nothing.
Means
right.
nothing.
But the
Absolutely.
attorney's here, we can do this. No.
Let's go back to the board for a second. Jennifer writes in, it's HOAs can have a budget meeting with a 48-hour notice. Then it states if levying a non-emergency special assessment, regular assessment, it's a 14-day notice. Which is it? Believe under the statute, it's both. Okay, so your budget only has to okay, let's teach it both ways. In a condominium, that budget now has to be sent, not now, for it's always been, the budget has to be sent out 14 days in advance of the budget meeting. Okay, so you send out the budget and you send out notice of the budget meeting in a condo 14 days in advance. And now what did we learn last week or the week before, whenever it was, you now have to send out 2 budgets if your budget has gone up by 15%.
115 or 15.
Right, as long as that's not related to Sears reserves or insurance. If your budget went up by 15%, now you have to send out 2 budgets, okay?
And one of them has stuff that's, what is the word? Indispensable? Dispensable?
Discretionary.
Discretionary.
Right. If your budget has discretionary
Thank you.
spending, you got to remove it. Okay. Now, HOA, it's different. HOA, the bottom line is your budget only has to go out with 48-hour notice. Condo, right? 14-day notice. HOA, 48-hour notice is fine, unless your governing documents say something different. Now, if there's going to be non-emergency special assessments for both, 14-day notice. Okay? Rob, back to the phones.
All right, let's go to Brandon. Or it's Amber from, I think that's Bradenton. Correct me if I'm wrong.
Or maybe she's in Brandon.
Could be. They're all next to each other. Yes.
Yes.
All right. Love that town.
Hey, you absolutely. It's all right. It's getting a little different now, but that happens. Quick question for you. So this is a condominium, COA. There was a recent board election. There was a person on the ballot that's not even an owner. That's come to light now, but it's not being put out. And I'm curious, should they have a re-election? How did the association not check that?
Okay, so hold on, let's stop there. Probably they should, but I don't know for sure. And this came up when I taught last week as well. 95% of the time, I would say, in order to be a member of a board of directors in a condominium, you do in fact have to be a member of that community. What does it mean to be a member? You have to be an owner.
Be on the deed.
Yeah, be on the deed, correct. 95% of the time, that's the way it is. You got to be a member. Now, what makes what you just said very interesting.
Can you be a wife?
Suppose you're husband and wife, and one of the two of you are not on the deed. And I don't care if you're living there 30 years.
Right.
Person that's not on the deed, not a member, no, they can't be on the board.
A lot of wives find out they're not on the deed this way.
Oh, I shouldn't even talk about it. I had a situation in this office where somebody found
I'm not
out
on the deed?
the hard way,
Yeah.
and let's just say was not happy about it.
I'm sure.
Okay. Now, but is it possible, however, that we have a situation where someone is not an owner and they wind up being on the board and it's perfectly legal? And the answer to that question is yes. Sometimes the governing documents do not require you to be an owner. So you can be living in another community and someone says, you know what, we'd love to have you. You're so experienced.
Yeah.
We'd love to have you on our board.
I thought that was common.
Quit based on her ineligibility.
Okay, and did a counsel for the association review the governing documents and come to that conclusion?
This is, I kind of have an inside word, and they had to find somebody else and put them on the board. So this, in fact, did happen.
Okay, well, I can't give you an answer as to whether or not what happened in your condominium is right or wrong, because there is a slim possibility that your condominium documents do in fact allow non-members to be on your board of directors.
They could be a director, but you can also hire a president to be on the board who's not an owner.
The good question.
So you have directors have to be.
Very, very good point. And then you could have a situation like Karen says, where maybe directors have to be on the board, right?
Or
I represented. You said it perfectly. I represented a community in Fort Lauderdale where there were a lot of intelligent people living in this community, and they actually went and they put somebody on the board who was not even elected as a director. I'm sorry, they didn't put them on the board. They made that person president of the community, even though that person wasn't elected, actually lost the election, but they made that person president. Why? Because the doc said you don't have to be a director to be a president, right? So you can have any number of combinations.
However, this is not, let's say hypothetically, that's not our documents. That's not what our documents say.
Right.
You must be an owner to be. Now, what it seems to happen is that the management company did not check and push the election through. So say that's true.
Okay, so clearly what I would tell you is clearly the DBPR would order you guys to have a new election if somebody would file a complaint.
Why would the management company want to put somebody that doesn't own?
Don't know. Maybe they just made a mistake.
They messed up.
Well, this is why for the managers that are listening out there, if there's one thing that I think the manager and counsel for the association should work together on, it's the annual election.
Yeah.
right? Because it's confusing. It's really, really confusing. Lots of different requirements that change all the time, especially in an HOA, quite frankly. Yeah, that's because of some arbitration cases that I was personally involved in, that it changes. You really got to know what you're doing now to do an election properly. You really need a reading of the documents. And management management companies and managers are not allowed to read the documents and provide an interpretation of those documents
Really?
as to what should or shouldn't be done. Why? The Florida Supreme Court calls that the practice of law.
Wow.
So if you're going to practice law, you obviously have to be a member of the bar. So I'm telling you, managers and attorneys
You can't
work
rely
together.
on them to read the
You should
document.
not be relying on your manager alone to do the election. The election's confusing. Get help from counsel. Okay? Yeah, so if you make that complaint, the DBPR will, in fact, order a new election if that person is, if you need to be a member and run for the board of directors and they weren't a member. So up to you whether you want to go that route, but I think you'd win it if you filed it.
A member is a
Okay?
homeowner.
Oh,
or
an
an
owner. Yeah, correct. Back to the phone,
Thank you
Rob. See what we
kindly.
got.
Thank
Sure
you.
thing.
Bye-bye.
Bye.
Let's see. We go to this is Mr. Johnson from Pembroke Pines.
Mr. Johnson, how are you?
I'm good, sir. How are you?
Okay, how can we help?
My question is on ARCs, the Architectural Request Committees.
Review committee.
Do they have to post when they're having the review, or can they do it, I guess, wherever they do it, and then just either deny or
Absolutely,
authorize it?
same thing. If you're going to have a quorum of the Architectural Review Committee meet, same thing. That meeting has to be noticed, and the unit owners have a right to attend. It's the same thing for committee meetings in
But
an
you said
HOA
they could have a
when it comes to the
committee.
ARC.
Oh, in an HOA.
Yeah, in an HOA, you can. But if a committee, if a majority of the committee is going to meet, then yes, that needs to be noticed. And remember, when I say the committee can address the board.
But you were talking about a committee that was going to pick,
Right. If a majority of that, but the committee is only two, right?
Right.
Yeah, committee could be only two. So, all right. So that's that. Yes, the same rules apply, right? When it comes to committees, if a majority of the committee is going to meet, it's a meeting, and yes, it needs to be noticed.
These boards forget who's in charge.
Yes, oftentimes they do. That's correct. Okay. All right. Who else we got, Rob?
Thank you.
Sure thing.
Let's go to the next caller is Mike from Miami.
Mike from Miami.
Morning.
How are you, Mike?
Good morning, everybody. How you guys doing? Good. Well, first of all, thank you so much for the show. It's amazing.
Thank you so much. Appreciate
Second
it.
of all, we basically have a 3-story building that has to have a fire inspection and repair on a few units, actually half of the building. The problem is that there's a unit owner that is not giving us access for a third time to her unit to change the horns. And we've notified properly. We've had his inspection. That's one of the units that we could not enter. And we notified, and unfortunately, she's throwing the paper away, littering the common area. And we actually request a possible officers to show up in the case that we have to go through with the locksmith. So
exactly.
Yep.
as a condo, we want.
Yeah, I had this issue come up this week.
The fire department can break the door down.
You guys can break the door down. Okay. Bottom line is, if it's a fire inspection, it has to do with the health, the welfare, the safety of the community, and the person won't let you in, hire a locksmith, right, and go in. You're allowed to go in during reasonable hours, right, for a reason just like this one, to protect the health, welfare, and safety of the people in the community. That's why the statute exists. And not only that, I'll guarantee you that if you look in your governing documents and your declaration, there's another section in your governing documents that say you can go in, right, when it's an emergency. And here, no question about it, it's an emergency. It has to do with a fire inspection, So 100%, the person doesn't want to let you in, get a locksmith, break the lock. When that person comes home from work, they're going to be a little angry that they can't get into their own house.
But you have the law on your side.
But law's on your side. Absolutely. Okay? That's the way I see it. Okay?
Yeah, I appreciate it. We actually notified the rules and regulations in the notice. So, like I said, we're not getting in this person, but we will definitely have a locksmith in the case that they don't cooperate. But Miami-Dade Fire Department hasn't been helpful. They basically are telling us that they can only enforce the common areas, not the interior.
Yeah,
which is
I get it,
unfortunate.
but that's where your job comes in as directors, and members of the board and as officers of the association. You have, again, a fiduciary duty to the people in that
That's
that
right.
community. Now, could you imagine if you don't do the fire inspection
Oh.
and God forbid someone gets hurt as a result of you not doing the fire inspection and you knew you had the right to go in and you didn't do it? Go in. Don't even think about it. Okay? Don't waste another minute.
Awesome.
Okay?
Thank
All
you.
right. Thanks for the call.
Thank you.
By the way,
Yeah.
Eric, an interested party wants to know, should the previous budget from 23-24 be available on the website, the community website, even if it was prepared by a previous management company? The new management company says they don't have it.
I don't think that the
How can you
old
not have your
budget needs to
budget?
be on the. You do have to have it.
Yeah, how
Yeah,
can they not
you
have
do.
it?
It's a
7
record that's
years.
7 years. I agree they do have to have it. Whether or not that budget has to be on the website is something different. I don't think the old budget has to. I think just the new budget
Oh, and
has
the
to.
old management says they sent it. Oh, boy.
Yeah, well, that happens all the time.
Yeah.
They have
Fights
to make an
between
effort.
management companies.
They have to make an effort to find it. though,
Right,
right?
exactly. Good point, Robert. So now, great point. So now under the new condo statute, and this is another thing that I was teaching people, right? Not only do you have to maintain the records for 7 years for both condos and HOAs, but in a condo only, why this doesn't apply to HOAs too, I don't know. But in a condo only, let's say you don't have the record, like this 2023 budget, they don't have it. It's not enough to say anymore, well, we don't have it, sorry, right? You got to make a good faith effort to get it. So for example, let's say somebody comes into the condo office and says, I'd like to see your insurance policy from 2019. It's only 6 years ago.
Mm-hmm.
And you say, 2019, who the hell has it? We don't have that.
We have,
Well,
remember that lady that was shredding everything?
yes, I do. That happens more often than you think, actually. But yeah, we don't have an insurance policy from 2019. And the owner can say, well, that's only 6 years ago. You're supposed to have the policies from 7 years ago. It's not enough for you to say to me you don't have it. As Robert said, under the statute now, you got to make a good faith effort to go get it. You better document those good faith efforts that you make, like calling the various insurance companies that you think might have been your insurance company at the time, calling your insurance agent, right? Calling your prior management companies. You better show that you made a good faith effort to get it, because if you don't make that good faith effort, you get sued, you're going to be found to have acted willfully, wantonly, and you're going to wind up paying that unit owner's attorney's fees, court costs, $500 penalty. There's going to be an injunction against you. The little records case can turn into a big nightmare.
And if you don't have the budget from the last year, you better have the year-end audit.
You better have the year-end audit, right? And you'd be surprised at the seminars how many people are telling me they don't have that.
Oh.
Yeah, I mean, it's really pretty wild. Yeah, and unfortunately, and the changes and the laws are becoming great. Who we try to teach on the show that the HOAs and condos should be coming together when it comes to these things, so everybody kind of knows it. There's no difference between one. The opposite is happening. Yeah,
They're
So,
not mirroring.
the opposite. So, for example, when you have to do your year-end audit now, condos now have until June 30th. For some reason, they got an extension. But HOAs, nope, you're still stuck with the
You know
April
what that's a
30th.
product of? That's a product of the legislature not understanding.
Maybe not. I just don't know why nobody's sitting down and saying, okay, how do we get these two types of communities to mirror each other a
Can you
little
talk
closer?
to them?
Going to have to, because
I think
things are
Yeah, it's crazy.
not good. It's making
just too much
correct.
for them to learn.
Correct.
You've got the mandatory education now. They need to make it easier.
Absolutely.
Because people's heads are exploding.
And they are.
Yeah.
That's exactly what they're saying.
Yeah,
Karen.
so
Their heads are
they need to streamline this.
And this is without talking about the SIRS and the SIRS
Right.
requirements and the reserves. And there's someone who writes in, I forgot where the question was, but it says, do we have to start fully funding by January 1st, 2026? And the answer to that is yes.
Yeah.
If you're in a building, actually a condominium building with 3 habitable stories or more,
Yep.
yes, you now have to start fully funding your reserves starting January 1st, 2026.
Even in Miami-Dade with the square footage.
Yeah, absolutely. That's let's not confuse reserves with inspections.
Oh, that's right.
So when it comes to inspection, to the inspections, yes, height may not matter, right?
Oh, I see. Excuse
but,
me.
But size may matter in terms of square footage. But when we're talking about reserves, everybody's on the same page.
Okay.
3 stories, 3 habitable stories or more, yes, you better start fully funding those reserves by January 1st, 2026. I know I'm dazed and confused. I wonder how they're feeling
Oh,
at
yeah.
home,
Sorry.
right? But that's what we're here for each week, everybody.
That's right.
And we'll continue to be here each week. That brings us to the end of yet another show. We are so honored that you tune in every single Sunday at 11 a.m. And if you need legal help off the air, you can give Glazer and Sachs a call, 954-983-1112. Again, 954-983-1112. We wish everybody a safe, fun, healthy week with you and your families.
Happy birthday, Bernice.
Happy birthday, Bernice. And again, we'll see you next week at 11 a.m. on Condo Craze and HOAs. Be good, everybody.
Thanks, Eric. Thanks, Robert.